I've had a long-standing interest in juries, and particularly in civil juries, and the relationship between juries and the communities from which they're drawn has interested me very much of late. So I teach complex litigation, and we talk about these huge cases. You think Vioxx or asbestos, something like that, where cases from all around the country often get concentrated into a single federal district for pretrial discovery and other procedural matters. And the centralization process, I think, is picking up, if anything. That's the trend, that's the future. And so if we're going to centralize cases into one particular place, then the question becomes whether a case then of national scope should be decided by a local jury, or my idea was that the jury should match the scope of the case it's deciding. And conversely, the community that's going to feel the impact of the decision should have a say in what the decision is. We proceduralists like to say, you take the substance, I take the procedure, I'll win every time, right? Because it really is all about the procedure, particularly in big stakes litigation. The people who litigate these cases tend to be repeat players. On the defendant's side, you often have a single, say, corporate defendant that's defending thousands of cases on the same topic. On the plaintiff's side, even though you have individual plaintiffs, you often have plaintiff's attorneys that are quite sophisticated in handling litigation, or consortiums of plaintiff's attorneys of various stages of formality that make decisions about where cases will be filed, often based on what jury pool they're trying to capture. So one of the things that my idea would do would remove the incentive to try to capture particular jury pools by making it possible for the jury to come from a national pool no matter where you file. Many people would tell you that we do. One of the major problems that the courts have grappled with for many decades is an underrepresentation of minorities in juries, and this was more directly the subject of an article I did previously. So that's been a sort of ongoing concern. And as to civil juries in big-scale cases, the concern is that the attorneys are manipulating who gets to decide these cases by filing in particular places. And there's been federal legislation in the last couple of years that's tried to respond to that by federalizing a lot of these cases, which wrests control sometimes from the plaintiff's attorneys, but still doesn't solve the problem. That's a question I think you get a lot of debate about. I think in the early days of the second wave of feminism in the 70s, particularly, the project was to try to eliminate explicit gender discrimination in the law. And that's largely been accomplished. So the pervasive concerns about things like sexual harassment, those things will always be around. But I think the interesting feminist project now is looking at the structure of things and seeing more hidden types of discrimination and what can be done about that structurally. There's always progress, yeah. I mean, things are no doubt better now than they probably ever have been for women, but there's still a lot of work to be done.